Okay. Welcome to Expert Views on ADR Ever, a podcast about simplifying alternative dispute resolution in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, PhD in ADR from the University of Brighton, United Kingdom, and I'm delighted to welcome Professor Susan Blank. She is a barrister and associate dean at the City Law School. She is also a co-author of A Practical Approach to Alternative Dispute Resolution and a co-author of the Jackson ADR Handbook. So welcome to the show, Prof. I'm so glad to have you.
Thank you for inviting me, Chinwe.
No worries. So without further ado, let's go straight to the question. So question one is, how far has ADR been able to enhance access to justice in the UK?
It's a really good question and a very timely question. As you're probably aware, the English courts are looking towards incorporating ADR in court processes, particularly for low-value cases. But focusing on the very essence of your question about access to justice. Clearly, there are problems with access to justice. Courts are expensive, court buildings are being dispensed with, there are an increasing number of litigants in person, and costs can easily outweigh the value of a dispute, particularly in low-value cases. And there are all sorts of other problems with access to justice. Even if you're putting justice online, have people got access to people and so on. So absolutely right to focus on access to justice as an issue. And I think, just to expand this concept of what justice is, and then absolutely happy to deal with your follow-ups. I think probably historically people have seen justice as being having their day in court, but it may well be that we need to really think about justice as whether you get a sort of time and cost effective outcome. So it's access to something that works for you.
Okay, thank you so very much. So instead of having their day in court, could also look at it as having time and less cost in settling your disputes. Okay, yeah. Oh, thank you so very much. So, do you think that ADR can do more in the future?
I really think it can, because if you're looking at people being able to access justice, I think we've probably moved on from the time when, particularly for lower value disputes, people should really see the court as being the answer. It's too difficult to get to, and so on and so forth. So I think it is going to be ADR that makes the difference. Of course, people have traditionally negotiated and so on. But if we look to making increasing use of mediation, you're probably aware that the current Master of the Rolls, Geoffrey Voss, has made some speeches about his idea that what should happen with civil justice is that people should, if they've got any kind of legal claim, just issue that claim. And then the state system should see whether that should be directed into ADR or go to a court. And I think that is the way of the future. That for a lower value dispute, you register it and you have a formally supported process, probably online, but not necessarily entirely online, where settling the dispute is facilitated. So information can be collected online if possible, and then a court official who isn't a judge can help people to make offers to each other and so on. So potentially quicker and cheaper, and only needing to go to a judge if it can't be resolved. So I would suggest that that is where we're going in the future.
At the moment, all right. Thank you. So, so what is your advice? No, it's not yet. The question is there any measurable difference or impact on the cost and time frame for settling disputes under ADR compared to litigation?
I like the way you put that as, is there a measurable difference? Because it's a question about what research can do. And I think then your question is quite a big one in terms of where you then go. Because you've got the point about different types of ADR having different timeframes and different costs, which you'll be well aware of yourself from your own work. So if you do an arbitration, that in a big commercial case can easily take as long as a trial, it can cost as much as a trial. So research there is often going to show that in a big case, you're not saving time or money with using arbitration instead of a court. You're simply choosing to use a more private system. So in those sort of circumstances, not measurably different. But certainly when you're looking at something like mediation, then that can easily be seen to be potentially quicker and cheaper, because you only need to set up the mediation, set up where it's going to be reasonably clear what the issues are, and that can take place relatively quickly, and it can be more cost effective. So you certainly can measure the differences, but I think it's also a question of what type of process you're using for what type of case, and whether you are looking to make it as quick and cheap as possible, or whether you're saying, well, I want it to be quicker and cheaper, and see how that works. And certainly a thing I always tell my students, teaching students who are training to be lawyers or doing a master's program, what should happen with ADR is that you get the sort of outcome that you would get if you went to court, so that you get your rights, but that you would normally get them quicker and cheaper with most forms of ADR.
All right. So what is your take on whether arbitration should be classified under ADR? Because we've had on this program some speakers that suggested that it shouldn't be classified, like Professor Nyama, that it shouldn't be classified under ADR, and she gave her reason. So what is your take, since it doesn't, these days it doesn't, of course, research has shown that it's more, sometimes it's more, most times it's more even expensive than litigation. So what is your take on that?
You asked some really good big questions. That one I think is almost impossible to answer, because I think that takes us back to what you mean by alternative dispute resolution.
Yeah.
And I think people are increasingly talking about appropriate dispute resolution.
Yeah.
If you mean, is it an alternative to court, which I think was the original meaning of ADR, then arbitration is an alternative to a state court system. But if you're looking for something that's an alternative to a full process where a third party takes a decision, then arbitration is fairly like a court process in many cases. You're just choosing an arbitrator instead of having a judge. So I haven't really answered your question. I've just said it's a good question.
Oh, well, you've done justice to that. So, because people are not really aware of the fact that most people they've defined ADR as an appropriate. Most textbook would say appropriate, not ADR. I think one of your textbook you kind of pointed out alternative, but however that other people it can be seen as an appropriate method as well. So it's really good that you pointed out here, so that other people that are not into ADR would also see that it can also be seen as an appropriate method as opposed to alternative. So depending on what the context is to them, or what they feel that ADR means to them, they can approach it that way. So thanks for answering the question. So what is your advice for potential users who might want to pursue a career in ADR?
Really big question, and I'll just give you a few points on it and then see if there's anything you want to follow up on. I think certainly anyone with a dispute should think seriously about what's the best way to address it. Historically, you have the sort of sue and be damned or see you in court approach that people think, I'm going to be tough, then I've got to take this to court. I think these days, everyone, even if they're wanting to fight a case very strongly, should look at ADR. And my advice would then be, look at the options for alternative dispute resolution. In your introduction, you were saying there are so many: arbitration, mediation, early neutral evaluation, expert determination. Try and get some basic information on what each of those is. Decide what is most appropriate to you. Is it that your dispute is mainly about some area of expertise like intellectual property, so that having an expert to determine it might be the best way forward? Is it that your dispute is like a family or neighbourhood dispute where you need to get on with somebody in the future, but you need to solve an existing problem, in which case mediation might be most appropriate? So think about what the options are, decide which is best for your case, and then prepare it. Experience I've had, and that some of my students have talked to me about, is that sometimes people go to mediation thinking, well, we'll just turn up and talk about the case. And of course, that's a possibility. But what I would advise is to be very well prepared. What is it you want to get from the day? What are the strengths of your case? What are the weaknesses of the case? So that you've got clear objectives and you've got thoughts about how to get them. Then you would hopefully find the process works reasonably well.
Okay, thank you. So the final question is, what is the way forward for mass awareness of the benefits of utilizing ADR in settling disputes or conflict?
Another really good question, and I wish I could answer that, because quite a lot of government reports and international reports have raised exactly that. How can awareness of ADR be spread? And also, how can awareness be shared? Because in different countries, there are different processes, different understandings of how things work. Some jurisdictions do have court processes linked to courts. Many of the states of America, and you were talking to me just before we started about that. So part of the problem is there are so many types of ADR. Part of the problem is that they're done in different ways in different countries. So it's not easy to see how you do get mass awareness. I think probably each jurisdiction does need to do more, probably in government terms, to give people more information. I know this is happening more and more, but people don't necessarily easily find the information. I wish I did have an answer. I think there are probably gaps in the market there for people who do provide really good information about what the ADR options
and also I would also add writing books like you've done and you're doing, simplifying ADR, because what prompted me to become an ADR advocate or going to study ADR was because of textbooks like yours, Margaret Moses, Emilia Onyema. So if more people could write more about ADR and simplify it, students would want to, like, okay, give it a go and say, okay, I'm gonna go into these routes instead of litigation. So yeah. So thank you so very much for your valuable contribution and insight on this subject matter. And as I would also add, in line with what the benefits you've outlined about ADR, especially on cost and time, is that no two people are alike, and hence disputes and conflict will always arise. But if they opt for ADR, of course, they can settle in timely fashion and save cost as well, and as well as understanding what prompted the conflict and how to go about it, and next time how to avoid conflict, as the case may be. So thank you so very much for coming on this show, and grateful. And to my audience, thank you for listening. Stay tuned for the same episode titled ADR and Workplace Conflict, a British Perspective. All right, bye. Take care.
Thank you, Chinwe. Goodbye.
Goodbye. Cheers.